Your Excellencies, you met the appeal for advice and support made on the floor of this very assembly at the end of January 2008 by my predecessor, the former President Mwai Kibaki, with a spirit of true brotherhood. You called on Kenya to commit fully to a peaceful solution through dialogue, compromise, and reconciliation. We heard you in Kenya and complied fully with your counsel. Through dialogue, we crafted a national accord which ended the violence and led to a power sharing through a grand coalition government. Excellencies, in just 2 years, this government oversaw an overhaul of Kenya's governance framework by ushering in a new constitution that entrenched stability, equity, and the redress of historical disparities. Our new dispensation is built on the rule of law, strong protection of human rights and accountability, its ability to ensure that the Republic is protected from violence sparked by political competition was confirmed by the peaceful election in 2013 that brought me to office. The path to reconciliation was accomplished by concrete efforts at providing relief, resettlement, reintegration to victims of the violence. Communities inspired by these efforts and the National Accord took up the work of reconciliation and involved many thousands in dialogue. These efforts continue to this day, and my government is committed to ensuring that they continue to succeed. This past November, an assessment mission of the status of Kenya's IDP by the AU's Subcommittee on Refugees, Returnees and Displaced Persons has recognized our efforts as a country. It concludes, and I quote, that the government of Kenya has put in place durable solutions by restoring those affected as much as possible to their original status, and has further reinforced this by initiating peace-building measures that will sustain peace and consolidate the confidence which government efforts have engendered amongst the different communities, end of quote. IGAD also concluded and conducted a similar exercise and has recognized the dedication with which Kenya tackled the plight of the victims. Your Excellencies, brothers and sisters, in times of adversity and crisis, we learn from our true friends, and we learn who our true friends are. There are those who pursued cynical opportunity in our difficulties. To further their political and economic agenda, they manipulated an international judicial system that is supposed to seek justice, peace, and reconciliation into bringing weak, politicized cases to court. Facts and evidence were completely disregarded. However, accusations, no matter how often they are made or repeated, is not evidence. As the cases began to show cracks from poor investigation, the world witnessed a concerted effort to divert its attention from the failure. The new scapegoat became the cooperation of the Kenyan government, which the court's own officials had spent the previous years praising as they were given unfettered access to the country. With the Kenyan cases came a progressive breaching of the Rome Statute's critical cornerstones of complementarity, admissibility, threshold, and gravity. Cornerstones that Africa, and indeed all Rome Statute signatories, negotiated and agreed. Observe closely and you will see that the court has unfortunately become more vulnerable to blatantly politicized designs. This new ICC, I poses a very grave risk to peace and security, not only in Africa, but to the whole world. What a far cry from the expectations and aspirations Africa harbored when it formed the decisive bloc that brought the court into being. We recall that there were powerful countries which announced their strong reservations about the risk of the court going down this path. We resisted their warnings in our desire for an international community in which all nations are on level playing field of justice and accountability. Unfortunately, every one of those reservations has been borne out in the Kenyan case, their assessment of the court was correct. Our experience underscores the necessity of amendments to the Rome Statute and serious reforms to the court. It must be able to live up to the expectations of its founders, and since 2010, Kenya has made strong efforts to spur reforms. But these efforts, just like the proposals made by the African Union, have been resisted. A damaging negativity by some state parties about the necessity for reforms has only made the court less likely to properly carry out its function when the whole world cries out for it. Perhaps the election of our brother, Sindiki Kaba of Senegal, as president of the ICC's Assembly of Straight Parties offers an opportunity, and following his election, he has made strong statements that Africa's concerns, as the largest constituency and the sole focus of prosecutions, are legitimate and deserve concrete responses. I hope is that wise advice will be heeded. Our relationship with the ICC is an acid test of our continent's place in the international community. Recall that our delegation of foreign ministers to the UN Security Council also encountered resistance to our message from a broad body that speaks often of supporting Africa's leadership in seeking peace and security within its borders. Despite such unhelpful stances, we have the ability to craft appropriate and effective solutions. We have the right to chart our own course and to correct our mistakes while staying accountable to our people. This was the burning conviction of our founding fathers, and it remains our cause today. We cannot wait for reforms which we have the power and indeed the duty to take our destiny into our own hands. Our continent's attorney generals, justice and foreign ministers and experts have crafted separate and interdependent mechanisms built to be responsive to the realities and needs of this continent. Today, we are poised to establish the African governance architecture, a broader African transitional justice policy framework, and an African Court of Justice and Human Rights. I dedicate myself to their implementation in a way that ensures that they are fully owned by Africa. And to this end, Kenya has just signed the Malabo Protocol on the African Court of Justice and Human Rights, and I will transmit the instruments to our Parliament for ratification. In addition, Kenya today pledges $1 million to the establishment of the African Court of Justice and Human Rights. I urge you, brothers and sisters, to join me in ensuring that the necessary ratifications are in place and the resulting court is fully owned, financed, and driven by Africa. This is an urgent and historical task that cannot wait. As I conclude, I want to inform this Assembly that one of the outstanding cases at the ICC involves our Deputy President William Ruto. Its progress is exhibiting the same pattern of weakness as the case against me. We look forward to its conclusion so that my deputy can join me in focusing exclusively on transforming Kenya and Africa and serving our people. Once again, I recognize the debt that I and the people of Kenya owe you and the whole people of Africa for your continued and unstinting solidarity. I am inspired by the spirit of brotherhood and unity that burns so brightly in our continent, and I assure you that with appropriate mechanisms put in place, we shall never be back at that court, and I would never wish to see the kind of pain that has been inflicted upon me and my brothers met upon any other African in the future. Let us own our own sovereignty with pride, with unity, and let us forge prosperity for our people together. I thank you very much for your attention. Thank you.